Have you ever been glued to a courtroom drama on TV and found yourself wondering, wait, who actually has to prove all this stuff? Well, in this explainer, we're going to break down one of the most fundamental concepts in the entire legal system, the burden of proof. Let's dive in.
So just imagine it for a second. You're in a courtroom. Someone points a finger and makes a serious accusation. Now what? Does the person making the claim have to prove it's true? Or does the person being accused have to prove they're innocent? The answer to that one question, well, that's pretty much the foundation of our entire justice system.
To get to that answer, we've got to start with the single most important piece of the puzzle, the fundamental rule that decides who carries that burden. Okay, so the official rule comes from Section 101 of the Indian Evidence Act. Now, I know it sounds a little dense and full of legalese, but the idea behind it is actually incredibly simple. It just means that if you go to court and you want a judge to rule in your favor based on something you claim happened, well, you're the one who has to prove it. So let's just boil all that legal language down to 4 simple words that you can always remember. You said it, you prove it. That's the core principle. If you're the one making the assertion, whether you're the prosecution in a criminal case or the plaintiff in a civil one, the responsibility, the burden, it's on you. Period. But, and you knew there was a but coming, right? This is where things get a little more interesting. See, the burden of proof isn't just one single thing. In any case, you're actually dealing with 2 different kinds of burdens at the same time. On one side, you've got the legal burden. You can think of this as the main mission, the big overall job of convincing the court that your case is solid. This burden is fixed. It gets assigned at the start and stays with that same party all the way through. But then you have the evidential burden. This one is more like a hot potato. It's the smaller job of just bringing enough evidence to the table to keep a particular point in play. And this burden can actually shift back and forth between the 2 sides as the trial goes on. So the person who says something happened has to prove it. Seems straightforward, right? Well, mostly. Because now we come to our first major plot twist, a really important exception to that fundamental rule. And this is where Section 106 comes in, and it's fascinating. It basically says that if there's a fact that is especially within the knowledge of one particular person, meaning they're really the only one who could know the answer, then the burden of proving that specific fact falls on them. It's kind of like the "you're the only one who knows" rule. Let's use a classic example. Say you get charged with traveling on a train without a ticket. The railway police can easily prove you were on the train. But think about it. How could they possibly prove a negative? How could they prove you didn't have a ticket? They can't. The existence of that ticket and where you put it is a fact that's especially within your knowledge. So the burden shifts to you to show the ticket. But, and this is a really big but, the courts are super careful about how they use this. A major case, Shambhunath Mehra, made it crystal clear that Section 106 doesn't just give the prosecution a free pass. They still have to do their job and establish what's called a prima facie case first. They have to show enough evidence to suggest that, yes, something is up here. Only after they've met that initial burden can the responsibility shift to the accused to explain something only they would know. All right, now let's get into the really dramatic stuff. We're going to look at specific situations where the rules of the game can completely change, and the entire burden of proof can actually flip over to the other side. This tends to happen in 2 major scenarios. The first is what we call a reverse burden, and it's actually written into certain very serious laws, like those dealing with drugs or the protection of children. The second is a powerful legal idea used when there's no direct evidence, and it's known as the last seen to get their doctrine. The logic behind the last seen doctrine is pretty powerful. It goes like this. If the prosecution can prove that the accused person and the victim were together, and then a very short time later something terrible happens to the victim, well, the law basically turns to the accused and says, okay, you were the last one there, you've got some explaining to do. The burden then shifts onto them to explain what happened in that time gap. And the consequences of not being able to explain are really serious. As was established in big cases like Mir Muhammad Omar, if an accused person can't provide a believable story about what happened after they were last seen with the victim, the court is allowed to draw an inference of guilt from that silence. But, again, the system has safeguards. The courts are really cautious here. Rulings from cases like Bodh Raj make it plain that just being last seen with someone is not by itself enough to convict them. The prosecution still has to provide other pieces of the puzzle, other corroborating evidence like a clear motive or maybe a recovered weapon, to build a complete, unbroken chain of circumstances that points to the accused.
So all of this brings us to one final and absolutely crucial question. We know who has to prove what, but how much proof is actually enough? What's the standard? And here, you can see a really sharp difference. For criminal cases, the prosecution has to climb a very high mountain. They have to prove their case beyond a reasonable doubt. But for civil cases, the standard is much lower, a preponderance of probabilities, which basically just means more likely than not, or even just 51%. And here's the real kicker. In those special criminal cases where the burden flips onto the accused, they don't have to meet that super high criminal standard. They only have to meet the lower civil standard of more likely than not.
So after going through all that, how do you actually put it all together in a way that makes sense? Let's quickly walk through a simple, logical checklist that recaps all the key takeaways.
If you ever want to figure out the burden of proof, just think through these steps. Step 1, who made the claim in the first place? They get the initial burden. Step 2, is there a specific fact that only one person could possibly know? That might shift things. Step 3, are any of those special situations, like the last seen doctrine, in play? And finally, step 4, what's the goal line? Are we talking beyond a reasonable doubt, or just more likely than not?
And that really leaves us with one last big question to think about. We've seen how and why the burden of proof can shift, sometimes onto the person being accused. But does that balancing act, which is designed to help find the truth, ever risk chipping away at that absolute bedrock of our justice system, the principle that you are innocent until proven guilty? It's definitely something worth thinking about. Thanks for joining me.